So sad when those crime stories are over. Listen, guys, we have Shayna Hubers. I'm told some new clips. I was just talking to Aaron. He was just here at the Law and Crime Network and sitting in the chair. He had some really interesting insights. As you guys know, he was down there, and there's nothing better than getting the feel of the courtroom. But I got Charles Mittelstadt with us right now, so we're going to switch over to the Hubers case and take a look at those clips. And, Charles, we'll talk about it on the other end.
Now, Ms. Fillier, on October 12, 2012, did you know Shayna Hubers?
No.
Have you ever... What about, did you know Ryan Poston?
No.
Were you working on the night of October 12, 2012?
Yes.
Do you recall who you were working with?
I was working with Sam Sampson.
Was she a fellow employee?
Yes.
And did she work for the same company you did?
Not Chanel, but in one of the makeup counters at Dillard's.
Okay. On that night, on October 12, 2012, were there any particularly noteworthy patrons or anybody who came to the makeup counter?
We had a girl who was visibly very upset, and she came in to see her friend Sam, and she was just very upset and kind of crying, and we all wanted to kind of help her and calm her down.
Did you learn by listening what that individual was upset about?
She found out her boyfriend was seeing somebody else.
Okay. And what did she tell you about it? Or what did she tell? Was she talking to you, or was she talking to her friend who she came to see?
She was talking to her friend.
Okay. And would that be Sam Sampson?
Yes.
And what did you overhear her telling Sam Sampson about she and her boyfriend?
She was just very, very upset, and she was kind of saying how she was going to kill him multiple times.
Can you say that again, please? I was talking over you.
Multiple times.
Okay. And did she say if she had been in communication with her boyfriend?
No.
Okay. Did she acknowledge whether anything had occurred between them?
No.
Okay, so this is Shayna Hubers, and this is Tara Fillitter. She met the defendant on the day of the shooting. It's a short clip, but you see once again the prosecution bringing out the same theme over and over again. And essentially, she was upset that the boyfriend was seeing somebody else. This is what she heard. I have with me Charles Mittelstadt. He's a criminal defense investigator. Charles, I mean, this evidence just keeps coming fast and furious over and over again with respect to the idea that she was very, very upset, Hubers, about the idea that her boyfriend was stepping out, if you will, with this beauty queen. I think it's pretty damaging, but I'm wondering if it's going to get to a point where it's just going to be overkill at a certain point. What are your thoughts?
Yeah, I think that potential always exists, Bob. But certainly, again, evidence of motive, the timing of the encounter with the defendant highlights the fact that she was very upset. And but again, if there is too much overlap, too much overkill there, then I think it has the potential to blow back on the prosecution. But I haven't had the benefit of seeing the whole trial, so I can't really opine on that. But it sounds like a good witness for the prosecution at this point. Yeah,
I mean, it certainly is. And, you know, it's interesting to me because there's different evidence rules, and this is what we always like to tell and impart to our viewers in each state. And the evidence book is the Bible, just like the Bible you would have in crime scene investigations. And if you can't get the evidence in lawfully, then the jury doesn't hear it. And in a lot of states, Jersey in particular, a lot of this evidence is hearsay evidence, and a lot of it would be really wobbly. I could see a court, not allowing at least some of it, or even as a prosecutor, sometimes if you put in a shaky piece of evidence, it's kind of on the line, and you're worried that the appeals court may not like it, you back up a little bit and don't continue to do it over and over and over again, because many times appellate courts will say it just became overwhelming at a certain point in time, and the evidence was suspect. And I don't know the state's laws there, but certainly in Jersey, this would be problematic.
Yeah, sounds like a great point. You know, if you get it out there and you get away with it, then don't push your luck.
Yeah, I mean, I'm just I always like to give anecdotal cases, like I'm sure you do when you're in your world. And there was a case that I have many of them, where the judge allowed 3 pieces of bad character evidence to get in, and I only used one because I felt it went to motive. And sure enough, in the appellate division, and then denied in the Supreme Court for appeal, the court said, Well, it did go to motive. The prosecutor was right. Had he used 2 and 3, we would have said it just would have been overwhelmingly prejudicial. And this is this balance you have to worry about, because it's not just winning the case. This case proves the very point. You don't want to have to come back as a prosecutor and try it again.
Exactly. You want to preserve that win. And in this case, I understand it was a juror that was determined to be a convicted felon. Is that correct?
Yeah. Child support problem. I guess the juror didn't know it was a felony conviction. Nevertheless, it didn't get reversed for prosecutorial misconduct. But again, the inertia is always against the prosecution when it's got to try a case a second time. Case is older, witnesses' memories fade. There's transcripts to better cross-examine witnesses. The second go-around's never as good as the first for prosecutors.
No, and that's why you generally see a plea that's more favorable to the defendant the second time around.
Yeah, not to mention the fact, and it's a very real consideration, because people think that law is 2 + 2 = 4, Charles. It's not that way. It's nuanced. It's relational. The victims' families many times are like, I just can't go through this again. And I've seen some who've actually been unwilling to cooperate. Now, we can compel them to cooperate, but it really takes the wind out of your sails when your witnesses are just deflated.
Absolutely. I had a case, in fact, it's a celebrated case called the Dion Ball case, which has been profiled by virtually every single investigative network now for the last 15 years. But same thing, resulted in a conviction, got overturned on the basis of the prosecutor eliciting testimony from the lead officer that he should not have. That was the basis of the case being overturned. Went to trial a second time. Got a hung jury, and on the third try, finally, the prosecution secured a conviction on the basis of a plea halfway during jury selection.
Right, that's the real world of trial.
It's a long road. That's a long road right there.
Absolutely. Listen, you were talking before about the anger that it's presenting, and anger is obviously a motivating factor. And I think the prosecution's done a great job showing that, but it's a perfect time now to go back to the 911 call that was made, because, this is something that I think is going to be compelling to the jury. It's a statement by the defendant. It's happening close in time to the incident. And Charles, we'll get to your thoughts about what's contained on that 911 tape on the other side.
Campbell County 911.
Ma'am, I killed my boyfriend in self-defense.
Okay, where are you at?
I'm at 12 Meadow Lane, Highland Heights, Kentucky, 41076.
Okay, 12 Meadow Lane. Are you in a house or an apartment there?
It's an apartment. It's apartment suite 10.
Is it Meadow, anything else, Meadow View or something?
No, 12 Meadow Lane. Ma'am, I killed him in self-defense.
Okay. Tell me again what unit you're in. It's not showing in my computer.
It's 10. It's unit 10.
Okay, you're at 12 Meadow Lane, unit number 10. Okay, hold on. What did you kill him with?
A loaded gun in the house.
Can you tell me where the gun is right now?
The gun is in the house.
Where at though, ma'am? Tell me where it's at.
I laid it on the bookshelf.
Where at? Laying on a shelf?
On the bookshelf.
Where are you?
I'm standing about 10 feet from his dead body.
Okay, are you sure that he is dead?
He's dead, ma'am. He's completely dead.
Okay. And how long ago did you shoot him?
I don't know, 10 or 15 minutes, not even that long.
10 or 15 minutes ago?
Yeah.
So you're going to stay on the line with me, okay? Because this is what we're going to do. The officers are going to want me to stay on the line with you, so when they get there, they're going to want to know where that gun is, and we want you to get out safely too, okay?
Okay, are they going to arrest me?
Ma'am, I don't know what they'll do. We're going to send them out. I'm going to stay on the line with you, okay?
I mean, I'm not a murderer, ma'am. I just killed him.
What happened exactly? What happened?
He beat me and carried me out of the house. He beat me and tried to carry me out of the house, and I came back in to get my things, and he was right in front of me, and he reached down and grabbed the gun, and I grabbed it out of his hand and pulled the trigger.
Okay. All right. Do you need an ambulance? Have you been injured?
I'm not injured, ma'am. I was thrown into the side of the couch.
Okay. And how old is he?
He's 29. He'll be 30 he would have been 30 on December the 30th.
All right. What's his name?
Ryan Carter Posted. He's an attorney in Cincinnati.
Okay. Have you had a history of domestic violence with him?
Yes.
Okay. And is this your gun?
No, this is his gun. He keeps loaded guns in the house.
So he slammed you into the couch, but you don't have any injuries?
I don't have any injuries. I was just very frightened. He's a lot bigger than me. He's 6'3", 200 pounds. I'm 5'8", 120. And he picked me up and was carrying me out of the house. And I said, let me get my things at least if we're gonna break up. And he wouldn't let me get my things. And when I reached around to try to get my things, he pushed me down from the door all the way to the couch, and when they come here, they'll see how far that is. He threw me across the room, and I was very startled. I was laying on the floor.
Okay. All right.
And I killed him.
Okay. Ma'am, this is what I want you to do, though. You're sure he's not, ma'am, you're sure he's not breathing at all? No, that's okay. They actually have someone that's outside almost right now, but I'm gonna stay on the line with you, okay? When they tell me to, what I'm gonna tell you to do is walk to the door with your hands up because we want you to come out safely, okay?
Ma'am, and then because he was twitching and I knew he was gonna die anyway, and he was making funny noises, I shot him a couple more times just to kill him because I knew he would have been.
I'm sorry, you said you shot him a couple more times after that?
Yeah.
How many times did you shoot him total?
I don't know.
Okay, because he was twitching and you knew he was going to die, so you shot him again?
And not to make sure he was dead because he was twitching so bad and I don't want to lay there and twitch.
So you shot him instead of calling 911?
Do what? Yeah, I did because I knew he was going to die anyway.
Okay.
It was pretty bad. He just was twitching when he was pretty much dead, and I shot him just so he stopped twitching.
Welcome back. We are in the Shayna Hubers case. That is actually the 911 call that she made. I'm with Charles Mittelstadt. And, you know, Charles, every time I listen to this 911 call, I'm getting more information out of it because it's a little difficult for me to make. I hope that they're going to clean this up a little bit so that you can hear over the operator. But, I mean, it gets, like, decidedly bizarre at the end.
That's the first time I'm hearing it. That is extraordinary. I have never heard a 911 call like that. I mean, how much time do we have to talk about? There's so many different aspects to it, but it's just shocking. First of all, she waits 10 to 15 minutes to call 911, and then she's teed up the self-defense argument already. But then she actually admits to firing two essentially coup de grace shots because he was going to die anyway. I mean, this is just unbelievable. I was listening to this with my mouth open. Unbelievable.
Yeah, and you know, I agree with you. And one of my mentors always used to tell me as a prosecutor when I was a baby prosecutor that the juries love to convict out of the mouth of the defendant themselves. And I think that this tape is all they really need to know because it's
slam dunk.
And by the way, it's not confirmed by the neighbors who have testified, these two elderly bitty kind of like elderly people, no disrespect by using bitty, but they were like, there was no argument, there was no yelling, there's no screaming, and it belies the evidence in the case.
Right, and then the absence of any injuries. At first, you know, her story continues to get worse for herself, right? She starts out with, he just pushed me on the couch, and then he pushed her across the room, she's on the ground, and she fires 6 shots. Just unbelievable. I mean, that, as a defense attorney, if you listen to that, you realize that you have some very high hurdles to overcome in defending that case.
Right, and you know, we also know there's testimony in this case that's going to show, Charles, that none of this was confirmed and that she basically wanted to give him, quote unquote, the nose job. It's just so bizarre. Hey, we got to go to a break. We'll come back on the other. Great analysis by Charles. Kentucky versus Shayna Hubers. We are listening to lots of anecdotal testimony from numbers of witnesses that are telling us about her being upset. The elderly couple that was living upstairs and didn't hear any noise or evidence of a fight. We just got done listening to the 911 call. She is on retrial for murdering her boyfriend, who was allegedly breaking up with her and getting ready to go on a date with a beauty queen. And the motive is murder by the prosecution side. However, she's arguing self-defense in this case. So now we're going to toss to a new clip that has yet to be heard on this network. It should be interesting. I'm interested as a prosecutor. How far do you keep going with these witnesses, especially people like Holly Nivens, who was the cellmate of the defendant? What does she have to say? Get in that chat room. Let me know. She helping the prosecution's case, not helping, or hurting? We'll be back on the other end.
I want to talk more about, did Ms. Hubers talk to you about time prior to October 12, 2012?
Yes.
According to Ms. Hubers and her statements to you, was she only present at the condo with Ryan Poston, or was there a time she was there without him?
Yes, she was there without him.
Did she discuss the type of things she would do when she was there without him?
Yes.
And what's an example? Please tell the jury what she told you she would do.
There's times that she would throw things around the apartment to make it seem like there was a fight going on between her and Ryan.
And was Mr. Poston even home when she was doing that?
No.
What was, according to Ms. Hubers, her purpose in doing that?
To make the neighbors think that there was something going on between her and Ryan.
You just mentioned the neighbors at the Highland Meadows condo complex. Did Ms. Hubers talk to you about anything else, any other interactions with the neighbors?
Yes.
What did she tell you?
She said that she would go and she would meet up with this little girl and one of the parents of the little girl.
Were they residents of the complex?
Yes.
Okay.
And she would purposely, roll her sleeves up to show bruises that were on her arms.
How did those bruises get there?
She said that she self-inflicted them.
And why was she self-inflicting bruises and rolling her sleeves up when she went to see the neighbors and play with the kid?
Because she wanted them to believe that Ryan was abusing her.
So what you've testified here today that on October 12, 2012, Mr. Poston wanted to end the relationship. What did he want of Ms. Hubers?
For her to get her things and leave.
And
To get her possessions, her things, and leave the condo.
And I want to clarify, Ms. Nivens, everything you're testifying to here today was told to you directly by the defendant.
Yes.
All right, Ms. Nivens is the cellmate of the defendant in this case, providing information to the prosecution and essentially saying that the defendant admitted, Ms. Hubers admitted to throwing things around the apartment to make it look like there was a fight and so that others would hear that there was that there was domestic violence going on, and showing bruises that she claims the defendant stated were self-inflicted in order to make it appear as if Ryan was abusing her. I don't know. I'm really curious. For those of you guys, please get in that chat room. Let me know if you have any questions. I really like you to listen to this testimony because, one witness can make, you sleep with dogs, you can catch fleas. You catch too many of them, you could get killed. Let's go back and listen to more of her testimony.
Where did Ms. Hubers tell you that the gun was located in the apartment during this?
On the table.
And was it in Mr. Poston's hands?
No.
Had he picked it up?
No.
Had he reached for it?
No.
Who did pick up the gun?
Shayna.
And once Ms. Hubers, in her own words, picked up the gun, what did she do with it?
She asked Ryan, she said, "What would you do if I," and pointed the gun at him.
I want to talk about, and what did she tell you after she picked up the gun and pointed it at Mr. Poston and said, "What would you do if I?" What did she say Mr. Poston did?
Smirked at her.
And what did she do at that point?
Walked around the table and shot him.
I want to ask you about that statement, "What would you do if I?" Have you heard that statement out of Ms. Hubers on other times?
Yes.
Can you please tell the jury where else you've heard that?
She had said that same thing at a shooting range when she had went with Ryan.
Did she tell you anything else about that trip to the shooting range with Ryan, that particular one?
Yes.
What was that? Please be loud.
Sorry. She had said that she was afraid that one of the employees there had heard her say that same thing to Ryan.
And when Ms. Hubers was walking you through this with the picture, did she tell you how many times she shot Mr. Poston?
Yes.
How many?
6.
And did she tell you why 6 times?
She said that she thought that he would be alive to say what had really happened that night.
Where did she tell you he was when she first shot him?
At the kitchen table.
According to Ms. Hubers, did he remain at the kitchen table for all the shots?
Yes.
At any point, did he fall?
He fell to the ground.
And what did she do at that point?
Went around to the opposite side and shot him.
While he was on the ground?
Yeah.
Ms. Hubers told you that Ryan Poston was ending the relationship on October 12, 2012. Did she make any comments to you about her view towards that or her actions towards that?
Yes.
What was that?
She had said that Ryan's family had a bunch of money and that they could buy a new child.
I'm sorry, can you please say it into the mic so they get it?
That Ryan's family had a bunch of money and that they could buy a new child.
After the shooting, did Ms. Hubers tell you what she did after shooting Ryan Poston?
Yes.
Can you please tell the jury?
She had called her mom.
And what, is that the first thing she did, or had she taken other actions prior to that?
She said that she had was trying to clean up the apartment.
Okay. I want to ask you specifically, you say she was trying to clean up. Were there specific items that Ms. Hubers was dealing with when trying to clean up?
Yes.
Please, run
Yes.
this mic. And what were those?
The gun.
What did she tell you that she had done with the gun after the shooting?
That she had wiped the prints off and put it in her purse.
And why was she putting the gun in her purse?
Because she had a conversation with her mom, and her mom said that she wanted to meet her, potentially.
And do what with it?
I'm sorry. Ma'am, you're going to have to speak
I'm sorry.
up. I apologize for keep asking you to speak up, but you're going to have to for the record. And if you need to get closer to that mic,
Okay.
you can get.
I
Please do.
apologize.
And you had said that they were potentially going to meet and do what with? What was the purpose of them meeting, she and her mother?
Well, they had phone conversation. On the phone conversation, she had said that they were going to try to make it seem like it was a suicide, or that they were going to, take the gun and come back either that following Sunday or Monday and make it seem like they had just found Ryan's body there.
Okay, Shayna Hubers trial, Holly Nivens, cellmate of the defendants, giving some pretty riveting testimony. What's going to be key here is, does she give information that is verified and corroborated that no one else could have known about the investigation? And secondly, what deal, if any, she got in order to give this testimony and how that affects her credibility? Pretty riveting stuff, talking about the kitchen table, went around that table and fired more. That's confirmed by the forensic evidence. And how would she know that unless somebody told her from the police world, which is unlikely? Ryan's family had money. They could buy a new child. Yikes, man. That is really damaging testimony that came out, that the victim's mother and father could buy a new child. Holy cow. That's bad. After the shooting, cleaned up, wiped the gun and put it in a purse. This is really great testimony, folks. Do you believe it? Don't you believe it? Let's see if she got any expectation of benefit, that's what we call it, by giving this testimony. We should find out pretty shortly because we got cross-examination of the defendant coming up. Holly Nivens is the witness. Shayna Hubers trial. Let's get to it.
She came clean last night and told the real story. And that's the one that you're telling the Commonwealth right then.
Coming clean and being comfortable are two different things. She's been comfortable the whole time that I was down there.
And maybe that's a poor question. What I was asking you was, this letter that you sent to Ms. Snodgrass, if you go back through it, that you told her, you said you have lots to tell, she told you everything about her case. Is that not true?
Correct.
Okay. So at that point in time, you know everything about her case. The time you're asking Ms. Snodgrass to give you a benefit, to move your case up, you know everything there is to know about her case. Please come see me. That's what she said.
That's what I said.
Okay. And then when they got there, and it was time for you to actually sell the deal and tell them everything that you knew, your story got sweeter. She told you a bunch of new stuff just the very last night, just the night before.
Objection, Your Honor. Argument of
Overruled. Go ahead. Please proceed with your cross-examination.
She told you a bunch of new stuff that very night before you were supposed to go in and have your audition.
Objection.
With the common law?
Argumentative, improper characterization, commentary.
Overruled.
I'll ask it again. The night before, that's when you learned, you said, again, and I'll directly quote you, you came clean last night. She came clean. You're talking about Shayna. She came clean last night and told you the real story the night before you're supposed to walk in there and see if you can get your court date moved up. Is that not true?
Can you ask that again?
This is an interview that lasts 1 hour and 13 minutes. At the 48th minute and the 15th second, you say, the night before you were supposed to go in and meet with Chief Birkenauer and Ms. Snodgrass, the night before that, Ms. Hubers told you she, quote, came clean last night and told you the real story. Is that not what you said?
That's what Shayna said, yes.
No, that's what you told to them.
That's what she told to me.
Okay. But the real story, that's your characterization. That's what you told them. Is that not true? I'm asking if you said those
Her
words.
characterization to me.
I'm asking you a yes or no question.
Your Honor, can the witness please be allowed to answer the question? He's cut her off twice.
She needs to answer yes or no, and then you can explain that.
Yes, that is what is said in that letter by Shayna's words. That's what she had said to me, what I am putting in the letter.
Okay, so she is giving testimony in the Shayna Hubers case, Cellmate. BB314 in our chat room asks a really, really good question. It's an evidential question. It's key in cases like this to know your evidence rules. Is this not hearsay, what the defendant said? It is. Right on the money, BB314. But there are about 1,000 exceptions to the hearsay rule, and one of them is statements against interest. If somebody says something, like a defendant makes a statement where they're confessing to a crime or saying something like that, it's admissible. Thank you, BB314, for that. We got to go to a break. This is fascinating testimony. We'll come back on the other end. Law and Crime Network.